Lord.
Yes.
My Lord, I beg to mention.
Asipur, Mr. Asipur,
Yes, sir. Lord.
how are you?
Going on fine.
A long time.
Long time. My son also come from summer vision.
Okay.
My
Yes,
Lord,
Mr. Luika.
I beg to mention item 10 and 11. My Lord, here I'm filing my affidavit of opposition.
Yeah, we did it today only.
So,
10 and 11.
yes, my Lord.
Okay.
So I'll be filing during the
You
course
also
of
came
the
for this?
Yes, for
10,
this.
11.
For this 10 and 11.
Oh, you are for?
petitioner.
You are for
Petition-
petitioner.
Petitioner.
I'm for respondent.
Okay, okay. So you want to file your?
Affidavit of opposition
Okay.
I'll
on
be
behalf
filing it
of-
during
on
the
behalf
course-
of,
during the course of
Officer
the day,
respondent.
my Lord.
Okay. Mr. H. Raman, learned senior government advocate.
Not government.
Oh, learned senior,
Senior advocate.
senior advocate. For the petitioner. Assisted by Mr. So-and-so.
I Javish.
Learned counsel. Also heard Mr. N.K. Wickham. The learned counsel for the sole respondent. Stop. Mr. N.K. Wickham. 6 for 2 weeks' time. To file affidavit in opposition on behalf of the sole respondent. Prayer is allowed, listed after.
Let it be in August
2
because
weeks.
July is our vacation. So let it be in August 21st.
Any fixed date?
20.
It's
Yes.
convenient.
21st August.
Listed on 21/8/2023. That's okay. Yes.
Much.
Much.
May I please, Your Lordship.
Yes.
Your Lordship, I beg to mention item, here in item number 21, on behalf of the counsel for the petitioner.
21.
Yes, Your Lordship.
Yes.
Your Lordship, I pray that this matter be listed after 2 weeks.
What is the matter about?
Your Lordship, I'm not in this case.
Yes, what is the matter about?
I'm for respondent number 1 and 2. I'm appearing on behalf of my senior in Lukumber.
What is the matter about? Mr. Vijmomi, are you there in this case?
No, I'm on behalf of the. So not on
On the prayer of the learned counsel for the parties, listed after 2 weeks. Okay.
Research. I beg to mention item number 8 and 9, an August matter. Worship, I pray that this matter can be taken up next week.
8 and 9.
Yes.
What is the matter about?
It's regarding the Uzu firing at Peck. Death of 2 children.
Who's firing?
Yes, at Peck. Worship, I have some personal difficulties today.
8 and 9.
8 and 9. 8 with 9.
These are 2 different cases?
No.
Same.
With. It is with.
Okay. Who's for the petitioner?
And for the petitioner.
Mr. P.B. Paul.
No. Yeah.
Oh, item 9, you're for the applicant. Eight and 9.
Worship,
Yes, Mr.
yes,
Young.
I think I made a, I think I made a mistake.
Yes.
Nine and 10, Worship. 9 and 10, Worship.
9 and 10.
Yes, Worship. No, only 9, Worship. Only 9. 9 is AA.
Nine is with
With-
10 with 11.
No, only 9.
9 is with,
9 is IA, with criminal,
okay, 9.
9, yes, Worship.
Okay. What is the matter about?
Worship, this is regarding to Uzu firing at back. So the 2 child has died in the firing. So we are asking that without the sanction from the state government, central government, as per the special power act, that the concerned officials should not be prosecuted.
Okay.
That is the case.
Whether some cognizance taken, charges framed by the civil court, by the ordinary criminal court.
The
Whether-
prayer has been made before the district and session judge, that has been dismissed. So that is what
What
we have.
prayer? What prayer?
The prayer that the
Not to
prayer
take cognizance.
not to take cognizance without the approval of, without the sanction of the central government as per the special power act.
Yes, Mr. Veto, are you for the state? Okay, when can we list it?
Next week.
Okay. All pleadings are complete.
No, Lordship.
Pleadings are not complete.
No, Lordship.
Will you be filing?
Yes, Lordship.
Then why are you keeping quiet?
Lordship, since I'm here to receive instruction, Lordship.
So you are keeping quiet.
No, Lordship.
Mr. V. Jimomi, the learned government advocate, 6 for 2 weeks' time
Lordship.
to file affidavit in opposition on behalf of the state respondents. What about the victim?
The another party, Lordship.
Why?
We are always seeing that sanction should not be granted without a sanction. Case should not be filed against the armed personnel.
What was the last? Yes,
And Lordship,
Where
there
is
is a stay order also.
prayer is allowed, listed after 2 weeks. There's an interim.
Yes, my lord.
You want extension of that interim?
Yes, my lord.
The interim order passed earlier shall continue till the next returnable date. Okay.
And
This is
Lordship,
item 9.
we must believe the LRC is also called for. Local court record.
Call for the LRC,
LCR.
LCR. Okay, call for the LCR.
Much obliged, Lordship.
May I please, your Lordship?
Yes.
Lordship, I beg to mention hearing item number 22, Lordship. Lordship, I have also taken the consent of the other side, Lordship. With the Lordship, if this can be listed on Friday, Lordship.
Not Friday, you take some other days.
Lordship, next week, Lordship.
On the prayer of the learned counsel for the appellant. Listed after a week.
Obliged, Lordship.
May I please, Lordship.
Yes.
Lordship, in this IA, I'm praying for the implement of the Office of the Accountant General as respondent number 4 in WPC 1.
Any objection? Heard, Mr. So-and-so. Learned counsel for the applicant. This application has been filed. Seeking for impleadment of the Accountant General, Nagaland, Kohima, as respondent number 4 in WPC number 117/2022. MS Inauli, the learned government advocate. Who appears for the state respondents? There is no objection to the application seeking for impleading. Stop. The Accountant General, Nagaland Kohima, shall accordingly be impleaded as the respondent number 4 in WPC number 117/2022. The application stands disposed. In WPC 117, okay. In view of the order passed in IS civil number 64. 64/2023. The Accountant General, Nagaland Kohima, is impleaded as the respondent number 4. Stop. Registry to take steps. Listed after?
Worship 2 weeks.
Listed after 2 weeks, okay.
Much obliged.
Why this is coming up as part heard? Why this is coming up as part heard?
Item 2, no?
There is no such direction. Yes.
May I
This is
please,
not a part heard matter.
Lordship,
Your Lordship, it was already heard, Your Lordship.
No, 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 no.
However,
I have only just passed orders as asking you to furnish necessary information, that's all. It was
yes, the
not heard.
direction,
Yes. Have you-
Lordship,
have you-
Lordship. No, Your Lordship, in fact, this matter is being handled by Mrs. Lucy, Your Lordship. However, Your Lordship, because of an unfortunate incident, Your Lordship, she is in the hospital now.
Oh. Oh,
She is still admitted in the hospital, so Your Lordship, if
okay, okay.
a 4 weeks time can be granted, Your Lordship.
What about the AG? Have you filed?
yes, Lordship, you have already heard.
Good.
May I please, Your Lordship?
Yes.
Your Lordship, it was already heard on
It was
25th.
not heard, it was not heard. If it is heard, I would have passed that order.
Yes, Your Lordship, my humble submission is that it was heard and then the government council was given a direction to bring instructions, Your
Yes.
Lordship.
Case has been wrongly listed as part heard. Registry to take steps. Mr. N. Angami, the learned senior government advocate, makes a mention on behalf of MS Lucy, the government advocate handling the case, and submits that MS Lucy has met with an accident and is indisposed. And therefore 4 weeks time. The learned government advocate is accordingly granted 4 weeks time to comply with the order dated 35/2023, listed after 4 weeks.
Deeply obvious, my lord.
Yes.
May I please, Your Lordship?
Yes.
Lordship, here I'm appearing for the petitioner, Lordship. Lordship, today I'm not prepared, Lordship.
What is the
so
matter
if-
about
Lordship, this is a criminal revision petition against conviction, Lordship.
against conviction?
Lordship. Lordship, I'm not prepared today. So if Your Lordship may allow 2 weeks of adjournment.
You're the counsel for the petitioner,
Yes, Lordship.
MS Lucino. The learned counsel for the petitioner submits that. Anyhow, what is this? he has some personal difficulties today. And therefore the matter may be listed after 2 weeks. Prayer is allowed, listed after 2 weeks.
Highly obliged, Lordship.
Review,
Lordship. It seems.
is it before the appropriate court?
Lordship, they have filed the review along with the writ petition, Lordship. In the writ petition, I have filed my affidavit today, Lordship.
Pardon?
In the writ petition, they have filed the review along with the writ petition, Lordship. So in the writ petition, I have filed my affidavit today, Lordship. And
What is the correct procedure? Yes. Is there a direction from the Chief Justice? No, nothing was there. Then how can it be just?
order was passed by my Lordship, Justice Soto,
That is why we are actually making clarifications.
Lordships.
What is the procedure to be followed when the honorable judge who had passed the judgment is no longer in the chair? What should be the right recourse? I think we have to place this before the honorable Chief Justice.
Lordship.
Yes.
This is my-
What was the order passed? Which is sought for review.
So the operative part, Lordship, the operative part is at page 30. Page 30 of the review petition.
Yes. 30.
30, Lordship. 6th line there. Therefore, it is hereby directed that the respondent should consider a petitioner for appointment to the post of peon line beginning in the government high school at Chenloso village. Since the wait on the part of the petitioner's family has taken so long, the same should be done within the period of 2 months from the date of receipt of the copy of this order.
And who has filed the review? State government?
No, Lordship.
What is your ground for review?
Lordship, I'm appearing on behalf of Mr. Senior and Kumar.
Who is the senior?
And Kumar, Lordship.
Yes. Why before confirmation this is placed? Who is in charge? Who? Call him. On what ground the review is filed?
On lordship, they are claiming appointment on land ownership basis. Lordship. And lordship, as per the order, they are challenging the order, which stated that in that order, lordship, the honorable court has directed the state respondent to appoint the petitioner lordship on land ownership basis lordship. Here the issue is lordship. There is a two land lordship.
Two landowners.
Two landowners lordship. However, lordship, the appointment arose in private respondent land lordship. The respondent number 5 in the review petition lordship. So appointment, there was a vacancy arose in that particular land lordship. So accordingly, the private respondent was appointed lordship. Now the petitioner is saying that
Petitioner's land is different.
land is different lordship.
Land is different.
Land is different.
So what you say is that he is also entitled.
After upgrading.
Just wait. What you mean to submit is that he is also entitled.
Lordship, but in case if there is an appointment there in that particular lot of land lordship, in that particular land lordship, then he can be appointed lordship. But however, as of now,
Okay.
lordship, since
So in
The
the land
vacancy-
donated by the petitioner,
lordship,
none has been appointed.
no lordship,
No landowner has been appointed,
no landowner.
including the petitioner or any of his.
Lordship. As of now, no landowner has been appointed on that particular state land lordship. However, lordship, the review petitioner, they are disputing that the appointment which was given to private respondent number 5, that land belongs to them lordship. But however, that has already been verified by the administration lordship, saying that that land belongs to respondent number 5, not to the petitioner lordship. That basically, that is issue lordship in the review lordship. So we will not be filing in review lordship. However, I have filed in the writ petition lordship, affidavit in opposition.
Okay. So when is your senior available?
Lordship, if this matter can be passed over for a day.
Possible for you. Okay. Possible for you.
Most obliged.
Matters, your lordship,
Yes,
lordship, and for the petitions.
Mr. B. Jimomi.
Lordship, my colleague Kyangam is appearing in this case, Lordship. So Lordship, he has some personal difficulty to the Lordship. So if this matter come up after I would, Lordship.
Your lordship, in this matter, in the last occasion, this honorable court has directed the parties to settle the matter among themselves.
Yes, so no settlement.
Yes, Lord, my lord, I have already contacted the respondent complainants. So far, there is
Who is
no
for the respondent complainant?
Gupta. Gupta. So far, there is no positive response from the ends of the respondent complainant. So this matter may be disposed of by quashing the CR case number 1 of 2022.
What is CR? What is that case?
My lord, the
What is that
case,
case?
the case which is pending in the Chief Judicial Magistrate.
What is that case?
Yes, that case is, my lord, with malafide intention to tarnish my image and to embezzle money from me, the respondent complainant has filed a case against me. So in order to, because of this, I come forward this honorable court to quash the private complaint case. Actually, my lord, this case is a reason from the contract work. This is purely civil in nature.
If there is a criminal element,
No criminal element. My lordship, in this particular case, the parties jointly enter into a tripartite agreement. And in para number 5, it is clearly stated that if any dispute arises, it should be always sent to the arbitrator to solve the problem. But instead of approaching the arbitrator, now they are coming forward this case, filing a case against me in the Chief Judicial.
that case is still pending.
Yeah, that case is still
Still
pending.
pending. Okay.
Yeah, so my lord, in order to quash this, since this is baseless.
Let us see that the agreement. Let us see that the agreement which provides for arbitration proceedings.
Yes, my
Let's
lord,
see that.
may I take my lord to page number 26.
26.
Yes, tripartite agreement.
Okay, just let us see.
My lord, particularly para 5, this is the relevant operative portion.
The first party, second party, third party.
May I read?
Who has instituted the criminal proceedings before the lower court? First party, second party, or third party?
My lord, second party,
Second party.
yes,
He has instituted the criminal case against
against me,
against
the
the
petition.
first party.
Yeah, against.
You are the first, and who is the third party?
There is no third party, my lord.
See your agreement, third party. Third part. See your page 26. Third part.
Yes, my lord, that I'm sorry, my apology. The third party is the respondent complainant. Yes,
Who is the complainant before the lower court?
the third party,
Third party.
yeah, respondent.
And?
Yeah,
The first party and the second party?
the first party is the contractor who has been awarded contract work. And now I am only executing the work.
You are which party? First party or second party?
I'm also from the first party,
You are
second party.
second party.
Yes,
FS Enterprises?
yes,
You are
Yes.
FS Enterprises?
yes, my lord.
So the dispute is primarily between third party and second party?
Now
Or-
dispute between is first, second party versus
Oh,
the
first,
third party, yes.
first, second party
Yes,
versus the third party.
yes, my lord.
So in the present case, the first and the second party, they are the petitioner
They are
and
the
the
petitioner,
third
my
party,
lord.
they are the respondents.
Yes. They are the petitioner, my lord.
Okay, okay. So where is that arbitration clause?
Now arbitration clause is, my lord, on page 28, para 5. If I may, my lord, may I read?
Just wait, paragraph 5. Okay,
That all disputes and question arising amongst parties in connection with the execution of this contract work or the terms and conditions stipulated in the agreement shall be referred to the arbitrator in accordance with the provisions of the Arbitration and Conciliation Act 1996, then in force. This is the main operative portion.
whether any recourse has been taken to clause 5 before instituting the.
No, not at all, my lord. No recourse has been taken by the respondent complainant.
There's Mr. V. Jimomi, so the
Lordship.
dispute is primarily between the private parties. Or whether the state itself, state is a necessary party here.
Oh, my lord, the state has nothing to do with this, only it is a raid because the case is filed within the state of Nagaland.
Within the state of Nagaland, so
Yes.
state is a party.
Yeah, that's why.
So you
we
may
have
have, basically, you may have nothing much to say.
Yes, Lord. If that is the case.
So. So it is Mr. Gupta. For 234. Respondent
Yes.
234,
234, my lord.
Mr. Gupta.
Yes, Mr. Gupta. Yes.
So where is he? Has he informed you? Has he informed you?
I have informed him and he.
Now, whether he has informed you that he will not be coming today.
Yes, he informed me
Okay,
last night.
so you have accommodated him.
Yes, so I said, I'm going, but I think I should pray before the honorable court to dispose of the matter.
Okay,
I just informed him that way.
okay.
My lord, my prayer is
What is your prayer?
simply, my lord, my prayer is to cause the order dated 23/2/2022 and summon stated 9/3/2022 passed by the learned chief judicial magistrate, Dimapur, Nagaland. Secondly, cause the proceeding of CR number 1/2022 pending trial before the court of chief judicial magistrate, Dimapur, Nagaland with exemplary clause. And also direct the respondents to return the invalid check to the petitioners. I've issued the check, my lord, and it has become invalid since the account has been closed. And I have already informed him to return the check.
Why does your prayer not include the arbitration?
My lord, my arbitration law says it is included in my statement, my lord. And pass any such further order or orders, your lordship may interfere in both. So that is my humble prayer, my lord.
We will send it for arbitration.
It's fine, my lord. But my humble prayer is to cause the CR case pending there in Dimapur. So they can approach any arbitration course. I'm welcome for that. Even I have informed him to go for the arbitration if he is not satisfied. But he didn't go for that. We only file a CR private complaint case.
But listed on 19th. Okay. Mr. So-and-so. Learned counsel appears for the petitioner. And Mr. V. Jimomi appears for the, and Mr. and Mr. Kiangami, Mr. V. Jimomi appears on behalf of Mr. Kiangami, the learned PP for the state respondents. None appears for the respondent number 2, 3, and 4. Listed on 19/6/2023. Stop. It is made clear that there shall be no further adjournment. And any adjournment shall be subject to post. Can you tell Mr. Kiangami to be on, to be there on 19th? Okay. You tell Mr. Gupta also about the order passed by this.
Yes, my lord. Like, obliged.
Yes,
Lordship, here we have received the affidavit in opposition from the respondents, and we will not be filing our reply. So let the matter may be fixed for admission hearing. Lordship.
what is the matter about?
Lordship, here the petitioners are challenging the settlement order and the order passed by the court below.
What is the settlement order?
Lordship, the settlement order was in favor of the respondent number 4,
Who has passed the settlement order?
Head Gambura.
Head Gambura?
The Taiko village Head Gambura, that is respondent number 2.
Okay. So against the order passed by head GB, you are here.
And also an order passed by the court below, Leonard Principal's district judge.
Okay, what was the order passed?
Lordship, Lordship, the appeal was dismissed due to lack of jurisdiction, Lordship. At first, we have approached the civil judge. And then on maintainability, the suit was dismissed, relying on the judgment passed in Civil Revision 6 of 2015. V. Hilo Aumi and versus Mrs. Kutoli Aumi. And after that, we have approached the DC. And the DC and the land in this, the DC has stated that the land in dispute is outside the cadastral area and civil in nature. And after that, no recourse was available in the office of the DC.
Yes.
And liberty was given to us to approach appropriate forum. After that, we have approached Learner Principal District Judge. And accordingly, it was dismissed due to lack of jurisdiction.
Why, Anshu? Why lack of jurisdiction?
Lordship, at the time of hearing, Lordship, the issue will come up, but now, since the matter has been adjudicated before the HGB, which is a village, the land falls within the village.
No,
Lordship.
no, the matter adjudicated by HGB went in appeal before the district and session judge. District and session judge says that he has no jurisdiction.
Lordship, that petitioner has to prove it.
You have to assist the court.
Will definitely, Lordship. Since they wanted to seek time for fixing up the matter, Lordship, if the matter can be listed on a particular date, Lordship, then we can take up the matter, Lordship. Well, assist the court, Lordship.
What is the reason given by the principal district and session judge? Citing that he has no jurisdiction. What was the reason given? Read your file and come at least. Is it page 41?
44, Lordship, 43 and 44 will be relevant, Lordship.
Starting from page 41.
Yes, starting from page 41.
Judgment is dated 15/10/2017. Page initial 8, no?
Page 35 is different.
No, judgment is dated 24/3/2021.
Lordship. 24?
24, 3.
Okay. It's not a question of the principal district just saying that she has no jurisdiction. They were delayed, Lordship. The petitioner, they are misleading the court, Lordship.
You start from page 44. However, no, you read para 10. Let's see, para 10, start from para 10.
Lordship.
You read para 10.
Lordship.
Yes.
Subsequently, through a notification, the post of DC Judicial, ADC Judicial, JMFC and JMSC were redesignated as District and Session Judge / Additional District and Session Judge, Chief Judicial Magistrate, Civil Judge, Senior Division, and Judicial Magistrate, First Class, Civil Judge, Junior Division. However, no amendment have been made to the rules to reflect the aforementioned redesignation. Therefore, under the rules, the courts of DC, ADC, Assistant to DC continues to be the court. Hence, till such time the rules are amended to make the necessary changes, the judicial officer with new nomenclatures holding regular courts under the Gauhati High Court have no source of power and cannot derive any judicial powers unless appointed or invested with the powers in terms of the rules for the purpose of discharging their judicial functions under the rules as Honorable Mr. Justice, retired Z. Angami, stated in the preface to his publication of the Rules for Administration of Justice and Police in Nagaland, 1937. It is also pertinent that the Honorable Gauhati High Court in its judgment in the Register General versus Union of India and others, reported in 2013, 4 GLT 1109, held that the rules will give way to the provisions of the Civil Courts Act to the extent of inconsistency in relation to functioning of court manned by members of cadre of judicial service. The appellant has also come under Order 41 CPC, but would also not be of help to the appellant as Order 41 talks about appeal from original decrees. The proceedings before the village court of Taiko village or the head Gambura of Taiko village was not a suit, and the impugned order is not an original decree, and the village council or head Gambura is not a court within the meaning of the Civil Courts Act.
Yes, it was dismissed due to, on the ground of a lack of jurisdiction.
No, Lordship, since this issue has been referred to the larger bench, Lordship, in view of the conflicting
Larger
judgment.
bench has decided via division bench.
Yes, one of the cases is still pending, Lordship. We have been informed, Lordship.
Which case? Which case?
Lordship, with that we have to ascertain, Lordship.
Lordship, in
One
Civil Revision 5 of 2020, Kevizate Sesa versus State of Nagaland, the court has disagreed with the views and decision taken by the coordinate bench of this court.
that is by Justice Kotishwar. Disagreeing to Justice Sato's,
I guess Devashish. No, Devashish. Lordship, I have the order.
there was one disagreement between the judgment passed by Justice Sato and,
Justice Devashish Baro.
Justice
Justice,
Arun Dev Chaudhary, Lordship.
oh,
And in that.
And
direction-
the Chief Justice has referred that matter
Yes,
to a division
matter
bench.
back.
Yes.
And the Honorable Division Bench consisting of Justice Surana and Justice Hokato Su, they've decided one matter.
That we have this.
That is also reported, Justice Surana and Justice Hokato's judgment. I don't know, but I think it's on a similar ground.
But your lordship, this case is still pending.
Oh. That is. No, that is, I think, on a different issue. That is whether the Washi's court has the jurisdiction to try and appeal of an order passed by a village council court. And there was also another case, Justice A.D. Chaudhary disagreeing with the judgment passed by Justice Sato.
Lordship, this is the case I have, and I have no idea regarding other cases.
No, what is that case about?
KV. KV Zati Sesa versus state. There's a judgment of.
Has it been finally decided?
Lordship, I'm told this is pending.
This is pending, lordship. I have no idea.
I think that order has been passed by Justice A.D. Chaudhary.
Yes.
A.D. Chaudhary
Yes.
disagreeing with the earlier judgment.
Justice Sato's judgment. This is pending.
That is pending.
Yes, Lordship.
And what is the issue in that?
Lordship,
What is the issue in that?
basically whether appeal just on the question of jurisdiction, Lordship,
Ah,
appeal shall lie with the
DC or
DC or the district.
the statutory courts.
Yes. Lordship.
Against the order passed by?
Justice Sato, because
No,
just.
no. Whether appeal will lie before DC or the statutory courts
Yes, Lordship.
against the order passed by?
Justice Sato.
no, the village.
Huh?
Village council.
Village council. So,
Village council.
yes. This is from the village council.
So Justice Sato has said,
Appeal will lie with the
District.
with the district
Judge.
in session judge,
Yes.
with the district court,
yes,
district court.
yes.
And Justice A.D. Chaudhary is in
And the
disagreement
judgment, yeah.
with the district, with the deputy
Yes.
commissioner,
Yes, because in terms of the rules,
31.
yeah, it should go to the deputy commissioner.
So this is also more or less the same case,
Lordship,
is it?
lordship.
More or less the same subject.
Same subject. Though the fact may be different, but the.
So what is the status of that case after reference?
Lordship,
We have
no
no.
idea, lordship.
knowledge about it.
Kindly
We
check up.
will assist the court.
Can you check up?
Yes,
Yes, Mr. Limawabang.
Lordship, I'm bringing that case in the civil revision. Lordship, the matter is pending before the division bench.
Ah,
It was listed on the previous week before your lordship was.
one by Justice Surana and Justice Hokato, na?
No, not that case, Lordship. Lordship, that Justice Surana and Justice Hokato case, that is whether the Toboshis can take up an appeal against the decision passed by the village authority. That's a separate issue. But Lordship, the present issue is,
Yes.
which is pending before the division bench. That is whether the district instance judge can entertain an appeal under Rule 31 against the decision passed by village authority. That is the issue, which is pending.
Okay.
so basically this same thing.
So the division bench before this Kohima.
Yes, Lordship. It was referred to the principal bench. But I'm from the principal bench, it has been transferred here.
Okay. So I think we will await that result.
Or maybe clap along with my case before the division bench. Civil revision 5 of 2000.
No, we will, what was civil
Civil revision 5 of 2020.
revision 5,
Five of-
2020, this is before the
DB.
honorable
Before the
division bench.
Yes.
Okay. I heard Mr.
Adjournment.
Isonso, learned counsel for the
Petition.
petitioner,
I'm for respondent 1, 2, 3, 1, 2, and 3.
Mr. N. Muzri, the learned counsel for the respondent number 1, 2, and 3, and Miss Lucino.
I'm for respondent number 4.
for the respondent number 4. Stop. All the parties are in agreement that the present case may be listed on disposal of civil revision 5/2022, which is pending disposal before the Honorable Division Bench.
Obliged.
Lordship, if my seniors, Mr. Ejimomi's name may be reflected in the Gauhati's Lordship
Okay,
as respondent number 4.
listed after the disposal of the civil revision petition 5/2022.
The name.
Lordship,
The name of Mr. Ejimomi, the learned counsel for the respondent number 4, shall be reflected in the daily course list.
Obliged.
Obliged.
Maybe Lordship.
Yes.
Lordship, kindly give me 3 weeks' time to file my reply to the affidavit filed by respondent 3, Lordship.
Oh, respondent number 3.
Lordship, I have received the
Who is the respondent number 3?
Lordship have taken the consent, Lordship, it seems he's in the, on his leg in count number 1.
Okay. So you want to file affidavit in reply,
Lordship,
Mr. Fuseko, the learned counsel for the
petitioner, Lordship.
petitioner submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit filed by the respondent number 3.
Yes,
Prayer is allowed, listed after 3 weeks.
Lordship, that's an interim, kindly continue.
The interim order passed earlier shall continue till the next returnable date.
Obliged.
Yes, who is for the petitioner?
yes, your Lordship, and for the petition.
Yes,
I filed my affidavit in reply, your Lordship, to the respondent number 2
when?
today, this morning.
Okay. Yes. No. It's not there on record. Affidavit in opposition. Okay, okay. The affidavit in reply filed by the petitioner is not on record. Registry, stop registry to trace the same and place it listed after a week.
Your Lordship, order dated 16/12/2022 may be extended to Lordship.
That is the interim order.
Not exactly interim, but as per this order, a direction was given that no coercive steps will be taken against the petitioner during the process of investigation.
Order dated
16/12/2022. The operative portion is in page number 3, last paragraph.
Stop. The order dated 16/12/2022 passed by this court that no stringent or coercive measure should be taken against the petitioner during investigation is extended till the next returnable date. Yes, what is this?
May it please your Lordship.
Huh,
My lord, here I have instructions to withdraw this application as my prayer for regularization of my service has been considered, my lord. Would my lord like to peruse a copy of this order?
Which is
I
your
am
name?
at serial number 3, lordship. Therefore, my lord, I would like to withdraw this petition with the hope that the impugned order would not affect my seniority.
That was not a prayer in your writ petition. This order was not born when the impugned order was there.
My lord. This is a subsequent development. In the impugned order, the private respondent's date of appointment is different from the date of appointment in the senior class, my lord. And
Okay.
therefore,
If you are aggrieved, you come with a new petition.
my lord, my lord.
So you are now appointed as regular sweeper,
Lordship.
regular sweeper. Mr. So-and-so, the learned counsel for the petitioner submits that in view of the order dated 7/6/2023 passed by the state respondents appointing the petitioner as regular sweeper in the Nagaland Civil Secretariat,
Yes, my lord.
in the Nagaland Civil Secretariat, Kohima, Nagaland. He has instructions to withdraw the writ petition. Stop. The writ petition is accordingly closed as infructious. Stop. The order dated 7/6/2023 shall be placed on record.
I'm obliged, my lord.
Here's Mr. Paseco.
Lordship, as per this honorable court's order, we have taken steps, and lordship, the respondent, they've been represented, lordship.
Yes,
Lordship, I have an instruction to appear for the respondent, lordship.
respondent number.
Lordship, they are sole respondent. Lordship,
Sole respondent.
yes, lordship,
What this is item,
13, lordship.
Orders, lordship.
the civil revision.
Lordship.
Okay,
Lordship, kindly list this matter after 2 weeks. In the meantime, I'll file my wakalat nama.
Mr. Senso submits that he has instructions to appear for the sole respondents and therefore seeks for 2 weeks' time to file power and affidavit
Yes, lordship.
and necessary affidavit. Prayer is allowed, listed up to 2 weeks.
Lordship is an interim, kindly continue.
The interim order passed earlier shall continue till the next returnable date.
Much obliged.
Yes,
May I please, my lordship, in this matter, my colleague KV is handling the matter, Your Lordship.
None appears for the applicant. Listed after 3 weeks on a date to be fixed by the registrar.
Obliged, my lord.
Yes,
May I please, my lord?
yes.
Lordship, even in this matter, my colleague KV Angami is appearing for respondent number 1 and 2, I'm told, Your Lordship. And by fine IA, Lordship, the respondent number 3 has been newly impleaded on account of a retirement, a voluntary retirement caused by respondent number 2, I'm informed, Your Lordship.
3. Yes,
I've taken the steps on 11.5.
respondent 3.
Lordship, I have no objection. However, Lordship may kindly see the board's order. It was passed in the month of April 2022. Now it's more than 1 year. They have not complied with the direction of this honorable court. Lordship, after filing this contempt petition, the writ petitioner expired in the month of August last year, Lordship. And subsequently, Lordship, the present petitioner, who is the wife of the deceased, substituted in the contempt petition. Now, in view of non-compliance of this court order, Lordship, the settlement of pensions in respect of the petitioner, deceased husband, has not been finalized.
What was the order passed by the writ court?
Directed the authorities to regularize in terms of the OM dated 17/3/2015, by which it is provided that the work church employees who are enjoying basic and who have completed 30 years of service is entitled for regularization for pensioner benefits.
You were enjoying scale of pay.
Yes, Lordship.
You were in service for 30 years and above.
My husband was serving for 35 years.
Yes. Then Angami,
Lordship,
I think
since,
he deserves regularization.
yes, Your Lordship. But since, however, Your Lordship, since I'm not in this matter, I cannot make any submission, Your Lordship. Sometime can
Mr.
kindly.
KV is for respondent number
I'm told that it's for respondent number 1 and 2. He was appearing for his
1 and 2. And so who is for 3?
Lordship, the present notice was issued on, I was taken steps on 11/5/23. New engineer in chief, Lordship.
Notice awaited. Service of notice issued upon is awaited. Let us wait for some time. Notice awaited. Okay. Office note dated 14/5/2023, 16/5/2023. Reflects that service of notice issued upon respondent number 3 is still awaited. Awaiting return service. Listed after 2 weeks. Okay.
Deeply obliged, my lord.
May I please your lordship?
Yes,
Your lordship, I have filed a Dusty today, only this morning.
Dusty?
Yes, Dusty service upon respondent number 1 and 2.
Oh.
So sometime may be given, your lordship.
You have taken steps
Upon respondent number 1 and 2.
through registry.
On the last occasion, I've taken steps to registered AD. However, notice was not completed, so I have to take Dusty steps again.
No, Dusty, personally.
Yes, your lordship.
MS so-and-so, the learned counsel for the petitioner, submits that he has taken steps for service of notice upon respondent number 1 and 2 by Dusty process only this morning.
Yes, your lordship. It's
So-
completed.
List the case after 2 weeks.
Deeply obliged.
Sir,
This is
Mr.
for consideration of the IA. Continuation of delay. I have filed objections.
You have filed objection.
I have filed objections.
Have you received the objection?
Yes, Lordship, we have received the affidavit in opposition. Lordship, will not be filing our affidavit in reply.
We'll list it for hearing. We'll list it for hearing,
For
for hearing of the application.
IA.
Yes.
Lordship. Otherwise, it may be disposed of at this stage also.
Okay. Are you ready?
Yes, Lordship, we have made a delay of 916 days, Lordship. So in IA 139 of 22, in para 7, page number 6, we have explained the reason why we have delayed in filing this McAfee. Page number 6, para 7. Lordship, I may be allowed to read that for you. Page number 6, para 7.
Yes.
Mr. Chief, shall I read that for you? That the appellant has a divisional office in Nagaland. It has a regional office in Gauhati, Assam. The appellant counsel on receipt of the said judgment could not forward the same to the appellant's divisional office situated at Dimapur in time due to the pandemic COVID-19. The appellant's divisional office on receipt of the judgment dated 19/11/2019 from its panel counsel based at Mokchung on 2/5/2022. The divisional office Dimapur forwarded the same along with file to its regional office in Gauhati, Assam on 4/5/2022 for approval or advice in preferring the appeal. The appellant's regional office on receipt of the entire file forwarded the file to its panel advocate at Gauhati for obtaining the legal opinion. The appellant's counsel based at Gauhati furnished the legal opinion on 19/5/2022 to the regional office. The appellant's regional office, through office letter dated 25/2022, forwarded the file to the appellant's divisional office to prefer appeal before the Honorable Gauhati High Court Kohima bench. The appellant's divisional office, on receipt of the entire claim file from the regional office, forwarded the file to the panel council at Dimapur via letter DAP legal dated 26/5/2022 for preparation and filing of appeal against the impugned order dated 19/11/2019 as advised by the regional office. However, the appellant's counsel was indisposed for 1 month due to typhoid. The appellant's panel counsel prepared the appeal and contended interlocutory petitions and forwarded the same to the appellant's divisional office in Dimapur on 22/8/2022. The instant appeal was finally filed on 23/8/2022. The period of appeal being 90 days from the date of judgment dated 19/11/2019. It was expired on 16/2/2020. Thus, there has been a delay of 916 days in filing this instant appeal, and the delay has been caused due to the reasons stated above, and not due to willful negligence or default on the part of the appellant's company. As such, the said delay in filing the appeal may be condoned, Your Worship.
What was the order passed by the Honorable Supreme Court on condonation of delay during the pandemic? Where is that order?
Here's the order.
Yes, let's see. The last order,
The first order passed by the Supreme Court.
the
COVID-19, yes, after March.
it was up to from 20, from which portion to which portion?
Due to the outbreak of COVID-19 pandemic in March 2020.
Yes, March 2020 till somewhere 2022. Mr. Tompok, I think you will have to consider this. This was the order passed by the Supreme Court.
8/3/2021.
No, before, after that also, there's
No, what is the period where the?
it is from March 2020 till somewhere, I think 22, some May or June 2022.
Your Lordship, the specific order states this. In cases where the limitation would have expired during the period between 15/3/2020 till 14/3/2021.
No. After that, there is the last order. It went on extending. It went on extending. And it extended up to, I think, somewhere in the middle part of 2022. Kindly see that, check up that. Because if the limitation period falls within that, I think.
But in this instant case, it was passed in November. So
November
January-
19.
So March, by that time, it had already expired. It had already expired. So your Lordship, and then they ought to have explained.
No, we will
But
not be very strict.
Your
on
Lordship,
limitation.
in that case, cost should be imposed, Your Lordship, because after so long, even if.
That's why
Yes,
I wanted
cost-
to see whether actually like it will be
Lordship-
justified in imposing.
Your
books.
Lordship,
Let us,
Lordship, I'll just.
you just check up the,
One, Your Lordship, it may be if Your Lordship is of the opinion, instead of letting the matter stretch on and on, but cost should be imposed in the instant case. That is
that's
my-
why I wanted to see
Yes.
that if the limitation falls within that period, which has been exempted by the Honorable Supreme Court,
Yes,
then where's the question of imposing cost?
it had already expired by then. By 30, by March.
The order was passed in November 2019.
Yes.
And the limitation which the Supreme
February.
Court has exempted started from March 2020.
Yes. So by that time, there was already more than 2 months of. Even after the limitation period had expired. November, December, January, it expired. January expired, so February, March, 2 months.
It was, they had sufficient time to file it within that period of time, but.
Mr. Tongpo,
Let-
in the interest of justice, I think we should not,
Your Lordship, they should explain as to why it was sent only in 2022. When the judgment was passed in November 2021, 2020. It is their duty to explain, but they have not
Lordship,
explained it.
that's why we
They are only
have-
saying that it was
Explain
sent.
the reason why we have delayed. In our IA 139 of 20 in paragraph 7, it has been clearly stated that why we have delayed in filing this matter.
have you explained the period from
Lordship, we have not.
2000, November 2019 till February 2020?
Lordship, because of the lockdown and my senior has some medical problems, so that's why we could not find this matter.
It's a blank. No explanation. Your Lordship may condone, but cost should be imposed in this case. There has been.
But you will not be the beneficiary of the cost. It
Your
is the Legal
Lordship-
Service Authority or the Bar Association which
No.
will be the beneficiary.
Your Lordship,
You
in
will not
this,
be the beneficiary individually.
Your Lordship, I'll place an order passed by this honorable court.
Okay,
If
okay.
Your Lordship may.
But
Court-
this court is not inclined to actually like impose any cost or to reject the application in view of the order passed by the Honorable Supreme Court.
In MAC cases, normally cost is imposed and in favor of the claimants. In this case also that was.
There is no hard and fast rule. There is no hard and fast rule.
But it is up to the discretion of this honorable court, so I leave it to your Lordship, but they ought to have explained. Because this kind of casual attitude. At least. The companies, even though it's a company, the company should also be. Taught a lesson that they cannot take things casually, your Lordship. But I leave it to your Lordship.
See, you bring the latest order passed by the Honorable Supreme Court.
All right, Your Lordship.
Okay,
Okay, Lordship.
this is only up to 2021. The period from 13/5/20, 15/3/2020 till 2/10/2021. So this is only for the period 15/3/2020 till 2/10/2021.
Yes, Lordship.
I think we have orders extending this period of limitation till sometime in the month of May, June 2022. So kindly check up,
All right, I'll do this.
kindly check up and place it on the next day.
All right, Lordship.
Okay, we'll list it on Thursday. Okay,
This coming Thursday, Your Lordship.
yes,
All right, Lordship.
listed again on 15/6/2023. Okay.
Your Lordship.
Much obliged, Lordship.
Yes. Same. Mr. Tongpo,
Application of delay, huh? Your Lordship, in this case, since the delay is. Huh? 60 days,
how much did?
60 days, Your Lordship.
Okay, I think you will be generous.
No. One.
Have you filed your objection here?
No, no, no,
No.
no objection, your lordship.
So that means you have no objection.
It may be condoned, your lordship. In this case.
Where have you explained the delay?
Paragraph number 7.
Paragraph
Page number 5, paragraph 7.
7. That the appellant has a divisional manager at this line,
Yes, lordship.
starting with this line.
Yes, lordship.
Mr. So-and-so. Learned counsel for the petitioner and learned counsel for the applicant, and Mr. Tongpok, founder. The learned counsel for the
Respondent 1.
for the
Yeah. I have 2 of them, no?
for the respondent number
1.
only 1
Yes, your lordship, the claimant respondent.
for the claimant respondent number 1. Who is for 2, 3, 4
2 is owner for the vehicle and 3 is the driver of the vehicle, lordship.
and 4? Or 2,
There's
3?
only 3 respondents.
Okay. None appears for the respondent number 2 and 3. This application has been filed under Section 5 of the Indian Limitation Act 1963, seeking for condonation of delay of 60 days in filing the connected MSC appeal. Stop. The grounds for the delay has been explained in paragraph 7 of the application. Stop. This court, on going through the grounds, explaining the delay, is satisfied that the petitioner has been able to satisfactorily explain the delay of 60 days in filing the present appeal. Stop. Mr. Tompok, the learned counsel for the opposite party, for the respondent claimant, for the respondent claimant, submits that he has no objection to the application seeking for condonation of the. Stop. After hearing the learned counsel for the parties and on perusal of the application, this court is inclined to condone the delay of 60 days and allow the applicant to file the connected MSC appeal. The application accordingly stands disposed. MSC appeal. The MSC appeal 8, na?
Yes, lordship. 8 of 22.
MSC appeal 8, in view of the order passed in IAC 181/2022. The appeal is admitted for hearing.
Lordship, the impugned award may be also stayed.
Yes, 50%.
Yes, Your Lordship.
What is the total amount?
11,87,758, Your Lordship. 11,87,758.
By which award?
Mm,
About this MSC 12. Judgment dated 31/5/2022.
MSCAS 12/2022. Awarded is 11,87,758.
LCR will be required, no? LCR will be required. Then we will be over there.
In IA 182. IA 182. Heard Mr. So-and-so, the learned counsel for the applicant, and Mr. Tongpok. Owner. The learned counsel for the claimant respondent number 1, correct?
Yes, Your
Claimant
Lordship.
respondent. This application has been filed. For staying. The impugned judgment and award dated. This is 31/5.
Yes, Lordship, 31/5/2022.
No, you see your page 2. Course title. Judgment and award dated 25/3/2022. Why this difference? Whereas the impugned judgment is 31/5/2022.
Your Lordship, page 2, here 31/5/2022.
Yes,
31/5.
whereas in the course title. See, I think you have you were actually feeling sleepy and then you had copy paste.
Copy paste.
My apology, Lordship.
I cannot comment on that. I am also guilty of such.
Yes, and you also say, oh, I think, yes. You also see the judgment and case number also different. See your course title in the matter of judgment and award dated 25/3/2022. That is also wrong, passed by the learned member Motor Accident Claims Tribunal Tueng Sang. This is Mokok Chung in MSC case number 7/2019. The impugned judgment which you have annexed is MSC 12/2020 passed by Mokok Chung. Everything is wrong. Everything is wrong. Everything is wrong. I think you will have to withdraw these petitions. Yes, copy paste. I think you have actually
Yes,
copy
Lordship,
pasted.
from about we have made some inadvertently some mistake.
Yes, so everything.
Lordship,
Whether you are
I may be allowed to correct it
Yeah.
and file afresh, Lordship.
Oh, you withdraw and then file afresh.
Okay, Lordship.
Okay,
All right.
because I think right from the beginning, there is something wrong.
Yes, Lordship. I'll do it.
Okay,
Yes, Lordship.
so you will withdraw MSC appeal also? Or whether MSC appeal is correct, just see. But when actually everything is wrong here,
Yes, Lordship, everything is incorrect.
everything is wrong. Everything is wrong.
Along with the items.
So ma'am, no orders, no orders. Okay.
I
No order.
apologize, Your Lordship.
The computer age has,
Made even the
Yes.
lawyers so lazy
yes,
that we will just sleep and then just
yes.
stretch our hands. Everything is copy pasted. Mr. So-and-so, the learned counsel for the. No, this is IA 181. Mr. So-and-so submits that he may be allowed to withdraw the application with liberty to file afresh. Prayer is allowed. The IA, the IA is allowed to be withdrawn with liberty to file afresh. So also, the next IA 182, so and so, same order. Okay, so also MSC appeal 822. Okay, same order. So you file afresh.
Yes, Lordship, I'll do that.
Okay, but this time don't sleep.
Okay, all right.
Okay.
Much obliged, Your Lordship.
May it please, my lord. I have
Yes.
completed steps upon the private respondent, that is the respondent number 2, and filed my affidavit this morning, my lord. I don't know whether it will be on the record of this honorable court. But I have filed affidavit this morning, my lord. Notice upon the complainant. This is a criminal
Notice
appeal.
upon the,
Complainant, my lord, FIR complainant, my lord.
okay, upon, that means upon the respondent number,
2, my lord.
by what? By what means?
Dusty,
By Dusty.
yes, my lord. A date may be fixed, my
The-
lord, for
The affidavit filed by the petitioner,
appellant, my lord.
filed by the appellant. Taking steps for service of notice upon the respondent number
2, my lord.
2 by Dusty process is not on record. Registry to trace the same and place it on record. Listed after,
2 weeks, my lord.
okay,
Lordship,
listed after 2 weeks.
Deeply obliged.
obligement.
Yes. Yes, Mr. Apok, what is this?
Lordship, today I'm ahead of Devnath.
Oh,
The other day I did not come on time.
what is,
Lordship, the challenge they have made is that,
Okay, my senior is outside. I may be allowed to call him.
yes,
the ground they have taken is that the policy that was part of the record in the tribunal is a fake policy.
is a fake policy?
That's the allegation they are making.
Yes.
Lordship, but on a serious note, the appellant has filed this appeal without his permission under section 170P.
Under 170.
Yes.
What is 170? What does it
Lordship,
say?
it's a permission to file for the appellant to contest on all on merit. But the permission was not taken
Permission has to be taken from the court,
from the tribunal, yes.
From
An
the
application has to
tribunal?
be filed
from the tribunal.
from the tribunal.
That permission has not been,
Granted, nor was any application filed before the tribunal. There was a verbal submission at the time of the hearing. But then the tribunal rejected it. So, in fact, the appeal has no legs to stand. There is,
have you raised that issue here?
Lordship, I not file any affidavit, but
Then, if you want to raise all these issues, I think you should take the chance.
Lordship, but I may be allowed to.
If there is nothing on record, then this
Since this is an appeal, and I'm going to base on the records of the tribunal, all my submissions.
Okay, just allow me 2 minutes.
All right.
Next week. No. This is the last one. Domestic mana? Post graduate domestic mana? Benar. Alam mo ta. Yes, wala.
Yes.
Lordship.
What is all this?
Lordship, these are some citations, Lordship. I didn't get it in SSC. So,
What is all this?
Lordship, these are some citations, Lordship. Some rulings of our.
What is this policy?
Yes, this is the details of policy, Lordship, which took place with the company in the year 2016.
In the instant case, Lordship, the policy exhibited.
Was it exhibited before the trial?
No, Lordship,
Then
no, Lordship.
how do you accept now?
Lordship, however, this
Without
appeal,
any prayer for, without any application,
Lordship,
seeking the leave of this court?
Lordship, however, Lordship,
You do kushi and everything, huh?
no, Lordship.
We are not accepting this. Unless you file an application,
Lordship.
we cannot just allow you to. Yes, what is your case?
Lordship, there is.
And have you taken permission to file the appeal?
Lordship, the Honorable Apex Court Lordship in 2011, 10 SEC Lordship has categorically stated that if I may be allowed to take a Lordship to the concerned
What
paragraph.
does it say? What does it say?
The Apex Court has clearly stated that if the insurance company is made a party respondent by the claimant, then permission under section 170 is not required. And however, on the same footing, the insurance company will be can take the grounds on merit. It is Lordship, paragraph number 15 of the.
Okay, what is your case? Let's see. What is your case?
Lordship, the respondents claimants filed the claim case before the Learned Motor Accident Claim Tribunal, Mokchung, Lordship, praying for compensation of the death of the deceased, Lordship, who died in a alleged motor vehicle accident on 3/10/2016 at Mokchung. Thereby, Lordship, the insurance company appeared before the Learned Tribunal and contested the case on merit. However, Lordship, in the instant claim case, Lordship, the alleged accident has taken place on 3/10/2016. But the said accident, Lordship, was not investigated by the concerned police station on the request of the owner driver and the claimant, as it was a compromise between the parties in the concerned police station. Thereby, Lordship, the claim case was filed under section 166 of the MV Act, which is a condition precedent under the section that rational negligence has to be proved by the claimants. As there was no police report except a mere accident information report, rational negligence was not proved by the claimant, Lordship. Thereafter, Lordship, the insurance policy exhibited by the claimant in the claim case, Lordship, it is a fake and fabricated policy as it was not issued by the appellant insurance company. And to that effect also,
The insurance policy.
yes, Lordship. The insurance.
You actually say that it is a fake policy.
Lordship.
It is a fake policy.
Lordship, it is a fake policy as it was not issued by the appellant insurance company. We have not issued such policy. However,
Whether that issue was taken up before the tribunal.
yes, your Lordship, and to that effect,
And what was the finding of the tribunal?
Lordship, to that effect, Lordship, the company has examined its officer as Lordship DW2
Okay.
to prove the same. And however, the Learned Tribunal,
LCR is there.
Lordship, it is
Okay,
there, Lordship.
okay.
If I may be allowed to go through the impugned judgment, Lordship. Page number.
What was actually the evidence adduced by the company on this
Fake
insurance,
policy.
yes, policy?
Lordship, after the policy was exhibited by the claimant's Lordship, it was found that the policy number, concerned policy number, it's not matching with our system, Lordship. Lordship. And to that effect, the officer of the company has been examined.
Yes, what was that? What was the evidence?
The deposition of the officer says, my name is Kamaljeet Roy and I am serving as a deputy legal manager of Tata AIG. I have been entrusted by the company from the zonal office to appear in connection with this case. Exhibit D1 is the authorization letter. It came to our notice that the policy of the offending vehicle is detected from not our system, that such policy is not issued from our office and the same is fabricated. Our office has taken action in this regard to this policy.
Your office has taken action.
Yes, as it is written, Lordship. His statement, Lordship. Our office has taken action in regard to this policy. We have served a complaint letter to the officer in charge of Tuli Mokchung, Nagaland, pertaining to this policy of said letter. The service of the complaint letter has been received, which is annexed in this letter, and tracking report has been acknowledged by the officer concerned. Exhibit D2 is the copy of the annexed police complaint. We have served a letter to the vehicle owner in connection with the false policy of offending vehicle and also by the investigator. Exhibit D3 is the letter served to the vehicle owner by the company, and exhibited D4 is the letter serving by the investigator. Now, Lordship, the tribunal mechanical.
No. Let us be a little more on that.
Lordship.
You have actually filed a complaint
Lordship.
against the manager of your this.
No. We have filed a complaint before the concerned police station, intimating the police personnel that the policy has not been issued by our company, and this is a fake policy, Lordship. However, to that effect, there was no stance taken by the concerned police station.
No, you were actually reading some lines about serving some.
Yes. The police, the complaint.
To your Mukukchung branch.
Yes, to leave.
To your Mukukchung branch.
No, we don't have a branch.
Lordship.
Just read that once more. Evidence.
My
Please
name
come near the mic.
Yes. It came to our notice that policy of offending vehicle is detected from not our system, that such policy is not issued from our office and same is fabricated. Our office has taken action in regard to this policy.
Yes. What action? What action your office has taken in regard to the fake policy? And
Lordship.
against whom?
Lordship, it was an internal inquiry, Lordship, and it was found that such policy was not issued by the appellant company, Lordship.
You have actually stated that the position states that you have taken action.
Lordship.
So action against whom and for what?
Regarding the fake policy, Lordship.
However, that's why
Lordship,
action against whom?
Lordship, we tried to inquire about the concerned person who has fabricated the document, Lordship. But however, we could not trace the person. And we have filed an FIR with that effect to the concerned police station, Lordship. However, that police station, the concerned affair complaint, Lordship, has not been investigated by the police, Lordship. And if
so impliedly it means that actually the policy was issued by your office.
No, policy was not issued by office, Lordship.
Though maybe by some miscreants.
Lordship.
But by your employee.
Lordship, with regard to that, Lordship, there are many fake applications available with the Google, Lordship, how the fake policy can be generated, Lordship. And if I may be allowed to show that some differences, Lordship, with the original policy and the fake policy, Lordship.
Okay, and what was the finding of the
Learned Tribunal, Lordship? Yes. Learned Tribunal, Lordship, has come to a finding that as the appellant company, Lordship, could not trace the original miscreant who has done this act, so company was held liable to satisfy the impugned order, Lordship. And to this effect, Lordship, principal bench as well as other high court has categorically stated that if the insurance company has no contract, insurance company will come into picture when it will have one contract of indemnity. So when there is no contract of indemnity with the insured, Lordship, appellant insurance company cannot be held liable. And if there is any liability, it will be burdened upon the owner of the vehicle or the driver, as the case may be, Lordship.
Has notice been issued to the owner?
Lordship.
What is the position? Has the owner appeared?
Lordship, the owner
Because he is one of the main parties. now.
Lordship. And Lordship, the case was,
Have you served notice on the owner?
yes, Your Lordship.
Let us see. Because now I think the owner must contest the case.
Lordship,
You have also published in the paper?
Lordship,
Who are the owners and the drivers? Let us see. The owner, 173.
Lordship, respondent number 3 is the owner and 4 is the driver.
And 2?
2 is the father of the deceased.
3 is the owner,
3 is the owner,
4 is the driver.
4 is the driver.
Whether they have contested before the court below?
Before the court below,
Yes.
yes, they have contested.
I think Mr. Apok, I think the owner will be very much a necessary party for this adjudication.
Lordship,
Because if
may I
the
satisfy your
liability,
Lordship?
if the liability shifts towards 3,
And Lordship, as per order dated 4/2/21. Sorry, Lordship, 10/12/2020, notice was issued and appellant to take steps within 3 days, and as per office note 4/2/21, service upon all the respondents are completed, Lordship.
yes, Mr. Apok, you want
Yes.
to?
Lordship, I will just take a short time. Lordship, about the allegation that the policy is a fake policy. Lordship will kindly go through the LCR, and we have filed as annexure 3 in the tribunal. Lordship, there is one person named.
See, Mr. Apok, is it not for the owner? Is it not for the owner to substantiate
Lordship,
how he
he
has
has
procured the
filed,
policy?
Lordship, in fact, the owner contested the case in the tribunal, and he has filed the affidavit. He was examined. They all had a chance. Everybody had the chance to cross-examine and examine the owner. He appeared, Lordship.
So why not he actually appear and contest this case?
Lordship, that I don't know why he's not agreeing. That I have no idea. I'm representing 1 and 2. That's all. That is the claimants. But Lordship,
Because this court may have to go deeper into that issue.
Lordship may not be necessary because
No,
in the affidavit they have filed before the tribunal, they are on one hand saying that the policy is a fake policy, but on the other hand, they are relying on the policy itself. Lordship will just look at the LCR and the affidavit in opposition filed by the company. They are relying on that. At para 9 of the
yes,
affidavit,
on which point they are relying
they are relying on the policy, Lordship.
to substantiate what?
May I just read that one,
Uh,
Lordship? Para 9 of the affidavit in opposition filed by the company, that the opposite party states that it reserves the right to contest the case on the ground available to the opposite party, number 1. Number 1 is the insurance company, as per the reservation clause incorporated in the condition number 2 of the contract of insurance entered into with the opposite party, number 1. So in one hand, they are saying that the policy is a fake policy. Lordship, the fake policy
was annexed as part of the claim petition. And there is a person named R.T. Chakravarti who has issued the policy. Now, instead of taking any action against this person, in fact, the tribunal has rightly.
Whether RT Chakrabarti is an employee of the
That's what,
insurance company.
he is an employee.
He's the national head, Lordship.
He is
National head.
national head.
Yes.
Means
He's the.
His signature that is
Lordship,
appended
the
to the
signature
policy.
appended, Lordship, the signature appended in the fake policy is not the original signature. It is a fake signature.
but he is your employee, you are vicariously liable.
Lordship, but
You see the law on vicarious liability.
Lordship. But it is not my signature, Lordship. It is not the signature of my employee, Lordship.
Have you examined this fellow?
No,
No, this mean was also not examined. It was not part of the.
only
You have been
list.
very casual. Okay, start. We will hear you now. This court will start this case assuming that the policy is genuine. Okay, start.
Lordship, the finding. Lordship, the finding of the learned tribunal, Lordship.
Yes.
It is internal page number 16 of my appeal memo, Lordship.
Yes.
Mr. So-and-so is examined as DW2 in his cross-examination here.
Where are you reading?
Lordship, internal page number 16, Lordship,
Of your appeal.
of my appeal memo, Lordship. The operative part is at page 16, Lordship.
This is appeal 6.
Appeal 6, Lordship.
Page number.
16, 16,
Okay.
Lordship.
From which line?
Lordship, from the second line, top, Lordship. Kamaljit Roy.
Yes.
Kamaljit Roy is examined as DW2. In his cross-examination, he admitted that their company office is located at Gauhati, Assam. Claimants counsel submitted that insurer cannot escape liability to pay compensation to the claimants. On the other hand, counsel for the insurer submitted by referring to the evidences led by DW2, who stated that the insurance policy in exhibit P3 is fabricated and fake. It was not issued from their office. The company office has taken action in this regard by serving complaint letter to the OC of Tuli Police Station, Mokchung, Nagaland. Complaint letter is exhibited as exhibit D2. The company office also served a letter to the vehicle owner informing that the policy is fabricated, hence company will not be liable. Learned Tribunal perused the oral and documentary evidences available on record. It is found that no particular person who is alleged to have fabricated the policy could be identified in the FIR. No criminal case against any such accused registered by the police nor inquired. No one in this regard was arrested. Therefore, it was found that the complaint lodged by the insurer is not justified, but simply a denial without proof of the contrary by evidences available on record. Learned Tribunal finds that FIR in exhibit D2 has no legal basis and ineffective in any manner. Submissions by the insurer that the policy is fabricated and fake. One is not accepted. Therefore, the tribunal Lordship. And it was not also taken with the Learned Tribunal, Lordship. However, Lordship, the principal seat of this honorable court has categorically stated that it is upon the insurance company that if such circumstances arise and if the information is passed on to the police, it is the duty of the police personnel to investigate the case, and it is also not the duty of the insurance company to take on books the culprit, Lordship. And if there is no contract of indemnity between the insurance company and the insured, and in such situation, Lordship, the appellant company cannot be held liable. It is categorically stated by the Honorable Principal Seat Lordship.
But here is a case where actually one of your own employee has signed the policy.
No, Lordship, it was not the signature, Lordship. If I may be allowed to put before you, Lordship, the original signatures of my employee, Lordship. Although those policies, those documents could not have been.
Why did you not take all this recourse before the lower court?
Lordship, as it is a contract, Lordship, there is, it is not allowed, we are not authorized to take it outside, Lordship.
No. You are actually saying that the person who had signed the policy,
Lordship.
actually it is not the signature of that person.
Lordship will be very much aware, Lordship, the signature appended in the fake policy, Lordship, it is not the digital signature. And in all the insurance policy, all the documents, Lordship, the signature appended thereof will be a digitally signed, Lordship, and it will not be a hand signature, Lordship. However, the signature.
So whether this person was your employee.
He is an employee, Lordship. He is the national.
He is your employee.
Lordship.
What action have you taken against him? If he has violated some of the rules of the insurance company? What action have you taken against him? That means you're all hand in glove. Right from the top to the bottom.
No, Lordship, but then.
You want to save this person?
No.
That is why you have not conducted any inquiry. If you are admitting that he is an employee of your company.
Lordship.
And he has signed this.
Lordship.
The insurance policy. What step?
Lordship, he has not signed, he's the signature appending in the fake policy, Lordship. It is not his signature, Lordship.
It is not his signature.
It is not his signature because the signature appended thereof, Lordship, it is a hand signature. And the signature which actually will be.
So why did you not send for forensic expert his original signature and the signature which is appended in the policy? At least you should have actually taken recourse to that. You should have sought the permission of the lower court, the tribunal.
No samples were also produced before the tribunal, Lordship. At least if that is the allegation. The samples should have been produced.
And Lordship will appreciate the fact that the policy number, Lordship, the policy number, if I may be permitted to go through with the policy exhibited by the claimant, Lordship. Lordship, on the left hand side, top, Lordship, it says agent/broker. Producer.
Which page?
Lordship.
Which page?
Yeah, this is not part of that. Lordship, the policy is not part of the. However, it is. Lordship, it is exhibited by the claimant in their claim petition, Lordship, annexure 3, Lordship. It should be page number 9, Lordship, internal page number 9.
Exhibit?
Exhibit annexure 3, Lordship.
Of the claim petition?
Of the claim petition.
Yes.
Lordship. Left hand side top, Lordship, it says agent/broker, producer name direct. Next.
Which one? Agent, broker?
Producer name direct. On the left hand side top, Lordship.
Just wait. Agent, broker, producer name direct.
Direct.
What is
Lordship.
this?
Lordship. it should be, Lordship, if it was actually been.
Has the original been exhibited? Mr. Apok, has the original been exhibited?
The.
No. This is not the original. Because if it is from the tribunal, then the original should have been exhibited, or original should have been in your custody.
Lordship, here, Lordship,
Where is the original of this? And where is the copy retained by the office?
Lordship,
When you issue policy,
Lordship.
you also retain a copy.
That's what, Lordship, this is not issued by our office,
Okay,
Lordship.
Mr. Apok, where is the original?
Lordship, it has to do with your insurer,
No.
not with me.
I am not the insurer.
I'm the claimant.
When you insure your vehicle,
No, I'm not a vehicle owner, Lordship.
oh, who is the vehicle owner? Yes, the vehicle owner is important.
Is a necessary party, Lordship.
Yes. The vehicle owner is a necessary party, or else we will shift the liability on him if he does not appear.
If I may
Something
be
is very
allowed to,
fishy.
Lordship, if I may be allowed to point out the difference, small difference, Lordship.
Yes.
Lordship, before my learned friend begins, this opportunity, they had it before the tribunal. They have never contested about this. They are merely saying that they have stated that it's a fake policy. But apart from that, they have not laid any evidence against that. No samples were produced. Did that?
Why are you trying to shield the vehicle owner, Mr. Apok?
No, Lordship, I am trying to
We'll bring
get
him
a
before
benefit
us.
for my
We'll bring him
client.
before us.
Lordship, appeal is a continuation of the original suit, Lordship.
But new things cannot be pleaded.
It is not a new thing, your Lordship.
This is
This
not
is a
a new thing.
continuation,
See,
Lordship.
Policy. Let them produce the original policy.
Lordship.
And why has he not exhibited the original policy? Only the photocopy policy is exhibited as P3. There's something wrong here. Something wrong, something wrong. When was the last notice issued? Let us see.
Office no.
Yes, with affidavit pertaining to the true proper publication. Has been duly published.
Lordship, may I just interrupt once. Apparently, in the DW's statement, DW1, who is the vehicle owner, the insured, he has stated in his clause that I have brought original insurance policy in exhibit P3, which is verified and found correct. That is the statement during the clause.
No, but let him come, let him come. Let him come and explain.
Lordship, paper publication has also been made, Lordship, and to that effect, an affidavit is also placed before your Lordship.
Exhibit 3, not policy.
Heard Mr. V. Devnath.
Lordship, may I just satisfy your lordship on one, the point of law, on one point,
Yes.
on the section 170B, which I've referred in earlier. Lordship, the law as it stands, if the appellant does not file an application before the tribunal seeking permission from the tribunal to appeal into contest on merit, the law says that without such application and without the permission of the tribunal, no appeal can be filed. That is the law that is.
Okay, we'll take all this into consideration, but what this court is now concerned is about the policy. Heard Mr. V. Devnath, the learned counsel for the appellant, and Mr. Apok Ponguner, the learned counsel for the opposite party number
1 and 2.
1 and 2. Where is the order deemed served? Any order passed deemed served notice?
No, Lordship.
Any order stating deemed served? By the order dated 18/10/2022 passed by this honorable court. The appellant was directed to publish substitute notice no. 12/9, where is that? By the order dated 12/9/2022. The appellant was directed to take steps for publication of notice upon respondent number 2, 3, and 4. In 2 local dailies. Have you published in 2 local dailies?
Not
In 2 local dailies, having wide circulation in and around Mokokchung district and in Nagaland.
I've published in one in Nagaland Post and the other in PRMM.
Stop. This order was reiterated again by the order dated 18/7/2022. Stop. Appellant has accordingly taken steps and has published the notice as directed by this court and has filed affidavit dated 31 10/20/22 to that effect. Today, when the matter is called, none appears for the respondent number 3 and 4. Despite the notice served to paper publication. In the course of hearing today, this court finds that the policy of insurance is one of the disputes which this court has to decide in adjudicating the present appeal petition. The no, stop. It is therefore necessary for the respondent number 3 to appear and contest the case. The respondent number 3, who is the vehicle owner, who is the owner of the offending vehicle, to appear and contest the case. You take steps
Lordship,
for
respondent 3.
respondent 3. You take steps by way of dusty process.
Dusty.
Yes, through the registry.
Lordship,
Okay.
Lordship.
You take steps by way of dusty process through the officer in charge to Lee Police Station.
Lordship,
Okay.
Lordship.
What was the last line, Mr. Obi? To appear and contest the case. The learned counsel for the appellate. No, not the learned counsel, the appellant shall accordingly shall once again take steps for service of notice upon the respondent number 3 by dusty process through the register, through the officer in charge of Police Station Tuli, District Mukokchung, Nagaland. The appellant shall accordingly take steps that correction should be made, okay? The appellant shall accordingly take steps for service of a dusty process. So for service of notice, for service of notice by dusty process through the registry of this court to the officer in charge of Police Station Tuli, District Mukokchung, Nagaland. Within a period of
3 days.
3 days from today. The case shall be listed after receiving the report of service of notice from the officer in charge, Police Station Tuli, District Mukokchung, Nagaland.
Lordship,
Mr.
with the Lordship's leave, in the meanwhile, if I may be permitted to file the additional documents.
Lordship,
Mr.
that may not be permitted.
B. Debnat is also allowed to file additional affidavit incorporating certain relevant documents, the admission of which will be subject to the orders passed by this court.
I may be given the liberty also, Lord.
Pardon?
Liberty to contest that, those fresh documents.
Let him first file, then we will see whether actually it will be admissible at this stage.
That's
And if
the
the court
question.
finds
I
that
want
it
to
is
raise.
admissible, then we will give you the liberty to contest the case. This is. I think here in this case, we will have to secure the presence of the vehicle owner. I don't know, but I feel that there is something fishy.
Lordship, we have only heard one side of the story.
The one side is, I think, sometimes more than enough.
Lordship, will satisfy your lordship.
Obliged.
Computer section, court 2 over.